Right now, somewhere in America, there is a folder on a prosecutor's desk. Inside it is something that would help the person they are about to put on trial. Nobody outside that office knows it exists. And the only human being who decides whether the accused ever sees it is the prosecutor holding it. There is a rule that says they have to hand it over. It has been the law for more than 60 years. It is also one of the hardest rules in American law to enforce, and when someone breaks it, almost nothing happens to them. That sounds like it should be a crime. Most people assume it is. So, let's walk through what the rule actually says, where it quietly stops working, and what happened to the only prosecutor anyone has been able to find who went to jail for breaking it. Start with the thing that makes this different from every other kind of cheating in a courtroom. In a trial, both sides are supposed to fight. The defense hides its strategy. The prosecution hides its strategy. That is normal. But the prosecution is not just another player. It has the police. It has the crime lab. It has every witness statement, every report, every test result. It sees the whole board. The defense sees a corner of it. So, the law does something it does almost nowhere else. It reaches across the table and tells one side, some of what you are holding does not belong to you. Hand it over. The case that made that a constitutional command started with 2 men and a killing. In Maryland, John Brady and Donald Boblet were both charged in the death of a man named Brooks. Brady took the stand at his own trial and admitted he was there. He admitted he took part. But he said one thing clearly. Boblet did the actual killing, not him. Brady's lawyer asked the prosecution for Boblet's statements. The prosecution handed several of them over. It did not hand over the one from July 9, 1958, in which Boblet said he committed the murder himself. Brady was sentenced to death. In 1963, the Supreme Court said that was a violation of due process, and the language it used matters more than the outcome, because of one phrase at the end. Suppressing evidence favorable to the accused violates due process where that evidence is material to guilt or punishment. And here is the phrase, irrespective of the good faith or bad faith of the prosecution. In plain English, it does not matter whether they meant to. Honest mistake, deliberate burial, same violation. One condition did fall away later. As the rule was written in 1963, it applied when the defense asked for the evidence. 13 years later, the court dropped even that. You do not have to know something exists to be owed it. Read the rule again and you find the trapdoor. It is one word. Material. Evidence is only material if there is a reasonable probability that handing it over would have changed the result. That sounds sensible. It is also the reason the rule is so hard to enforce. Because it puts the question in 2 places, and neither one is where you'd want it. First, before the trial, the prosecutor has to look at the file and predict whether a piece of evidence would matter to a jury. They are guessing about the future, about the strength of their own case, and they are doing it alone. There is no judge in the room. Usually there is no defense lawyer either. Nobody is watching. And the duty is wider than the prosecutor's own desk. In 1995, the Supreme Court took a case where the evidence that would have helped the defendant was never in the prosecutor's file at all. The police had it. They never passed it on. The court held that does not matter. The prosecutor has a duty to find out what everyone working the case for the government knows, including the police, 5-4, which means the honest answer to "I did not know" is that you were supposed to. Second, if it comes out years later that something was buried, an appeals court asks the question backwards, not should they have turned it over. Instead, knowing what we know now, would this have changed the verdict? And if the court decides you would have been convicted anyway, the conviction stands. The evidence was hidden. You still lose. In 2017, the Supreme Court did exactly that. 7 men convicted in the 1984 killing of a woman named Catherine Fuller in Washington, D.C., found out the government had held back 7 categories of evidence, including the identity of a man seen near the scene who later attacked other women. The court did not say the evidence was handed over. It said what was held back was too little, too weak, or too distant to have changed anything. 6-2. The conviction stood. Justice Kagan dissented. It does not always go that way. In 2012, the court looked at a New Orleans case where 5 people were shot dead inside a house. One survivor told the jury he had been face to face with the gunman and had no doubt it was a man named Juan Smith. What the jury never saw were the detective's notes from days after the killings, where that same witness said he could not identify anyone, that he could not see faces, and that he would not know them if he saw them. It was the only evidence tying Smith to the crime. The court threw the conviction out, 8-1. Now the bigger problem, and it is the one almost nobody hears about. Everything we have described is a trial protection. Brady is about what you are owed before a jury decides your case. But most people never see a jury. In the federal system in 2024, about 97% of people who were sentenced had pleaded guilty, not been found guilty. Pleaded. The trial that Brady protects is the thing that almost never happens. So, the obvious question is whether the government has to show you the evidence that helps you before you decide whether to plead. In 2002, in a case called Ruiz, the Supreme Court answered it, unanimously. And the answer is not the one most people would guess. No. The Constitution does not require prosecutors to hand over evidence that would undercut their own witnesses before you plead guilty. The court's reasoning was that this kind of evidence goes to whether a trial is fair, not to whether your decision to plead was voluntary. So a person can plead guilty, go to prison, and never learn that the state's main witness had been caught lying. Which brings us back to the question we started with. If someone breaks this rule on purpose, what actually happens to them? In 1987, a district attorney in Williamson County, Texas named Ken Anderson prosecuted a man named Michael Morton for beating his wife Christine to death. There was no physical evidence tying Morton to it. Anderson told the jury he did it. The jury agreed. What the jury never heard. The Morton's 3-year-old son had described watching a monster attack his mother, and had said his father was not home when it happened. Neighbors had reported a man parking a van behind the house and walking off into the woods. A bandana covered in blood had been found near the scene. Michael Morton went to prison for nearly 25 years. While he was in there, Ken Anderson's career went the other direction. He was made a judge. DNA testing eventually cleared Morton and pointed at another man. In 2013, Anderson resigned from the bench, pleaded to contempt of court, agreed to give up his law license, and was sentenced to 10 days in jail. He served 5. And the reason that number is famous is not that it is small, it is that it is the only one. The Innocence Project, which tracks these cases, says Anderson is the only prosecutor who has ever spent a day in jail for misconduct that put an innocent person away. One in the whole history of the country. One thing did change, and it did not come from a court. In 2013, the Texas legislature passed a law and named it after him, the Michael Morton Act. Before it, a Texas prosecutor was not required by state law to show the defense the file at all unless a judge ordered it. Now, on request, they hand over the offense reports, the witness statements, and anything that might help the accused, and they have to keep a record of what they turned over. It passed the Texas Senate unanimously. So, the rule is real. It is constitutional, it is 60 years old, and it says the state has to give you what helps you. What it does not have is much of an engine. The person deciding whether to follow it is usually the only person in the room who knows there is a decision to make. Defenders of that arrangement say prosecutors could not function under a stricter one, that they'd be second-guessed on every judgment call and buried in retrials. Critics say a duty enforced only by the person bound by it is not really a duty at all. Both of those arguments are still live. What is settled is the rule, and how rarely anything happens when it is broken. Now you know.